Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. My name is Keith Fuicelli, and I am thrilled to host another episode of the Colorado Trial Lawyer Connection podcast. And I am very honored today to have my good friend, Alana Anzalone and Melanie Stuckey, here to talk about a truly amazing verdict that they received in Adams County not too long ago. And I sometimes think of verdicts like baseball games. So you either, strike out and you lose, or you get a single, a double, triple, or like this case, you truly hit a home run. And this case is the definition of an amazing home run verdict in what I have found to be a very sometimes difficult venue. So without further ado, welcome to the show, Melanie and Alana.
Thank you.
Before we jump in and talk about this case, Alana, I know you have been on before talking about a previous amazing verdict that you are just crushing it. And I should say that Alana is with the Anzalone law firm. Did I get that right? Is it Anzalone law firm?
Anzalone law offices, but close enough.
People will know how to find you if they want to find you.
Yeah.
And Melanie works with the Donaldson law firm. Did I get that right, Donaldson?
Yep.
I messed that one up too.
Donaldson Law. Yep.
Both, we should say, amazing women-powered law firms and women out there just kicking ass and taking names. So congratulations to you both on your professional success and on this verdict. So kudos to you both.
Thank you.
Before we jump in, since you have not been on, Melanie, and perhaps maybe people don't know you, how is it that you came to be a plaintiff's trial lawyer?
So I was a paralegal for 25 years, and 20 of those with Donaldson Law. And I went to law school and finished in 2020 and became a plaintiff's lawyer. Just stayed with the firm because that's what I wanted to do. So
now, did you go to law school at night?
Yes, I did. I went to DU.
Wow. It's just, how inspiring is that you were a paralegal for 20 years and then at the ripe old age of 30, you decide you want to go to law school at night. And here you are working full time, going to law school at night. What was that experience like for you?
Looking back, it went really fast because you're just so busy. You don't really have time for much else. I overloaded, so I finished in 3 years instead of 4. So I went during the 2 summers, I took classes and I started overloading my 3rd semester. I just felt like I was too old to go to law school for too long, and I just wanted to get it done. So that's what I did and finished in 3 years.
Wow, it's so inspiring that you have presumably a very comfortable job, you know what you're doing, and then you decide to take the Indiana Jones leap of faith and decide to go to law school and become a lawyer. I mean, your family must be so proud of you to have done that. Was it a difficult decision to make, or was it an easy decision to make?
It was pretty easy. I had always wanted to go to law school. And then when I had my son, I decided it was more important to be a parent. And I had a great job with Jennifer Donaldson. So, but when he was graduating from high school, he started asking me lots of questions about why didn't I pursue my dream? And so I started looking back into it and decided, you know what, I'm just going to do it now. So he started college and I started law school at the same time.
Wow. That is so cool. I can't imagine that there were many people more proud than your son at your law school graduation. That is so amazing.
Yeah. Well, unfortunately, since I finished in 2020, I didn't get to have a graduation, but yeah, I mean, I took the bar and everybody was really proud of me for passing the bar right away. So
they didn't have like a Zoom graduation or anything?
They didn't do anything for us at all. They invited us to be on the Zoom graduation in December, and they invited us to come back for actual graduation the following May. But I was over it by then. I was working as an attorney and busy, and so I just decided not to do it. So too much to the chagrin of my mother, who was not happy about it.
Now, working with Jennifer for 20 years, I'm assuming that whole time majority doing personal injury plaintiffs work.
Yes.
When you went to law school, did you know you wanted to come out and be a trial lawyer?
Yes, I did. Yeah, absolutely.
How did your experience as a paralegal prepare you to become a trial lawyer? Was it essentially a seamless transition? Were you like ready to walk into court the minute you got your ticket to the show?
No, I don't think so. Had to learn to deal with people in a different way, being more responsible for the cases than I was as a paralegal. And then, yeah, court, I did trial practice classes and stuff, but it's never going to be the same as going to court for real. So, I think this was my first trial. So it was definitely a huge learning experience. And I was grateful that Alana was with me for that.
You were reading my mind because as you were telling the story, I was thinking, okay, how many trials did Melanie do between graduation and this case? And this was your first trial.
Yes.
So did you reach out to Alana and say, hey, I've got this case going, come help me?
Yeah, when it was pretty clear we weren't going to get it resolved, I knew I wanted someone to try it with me, and so we reached out to Alana and asked her to join us as co-counsel.
Talk to us a little bit, and some of our listeners. Sometimes I think people are hesitant to co-counsel with cases. They think they can do it themselves. They're worried about splitting fees, etc. What would your advice be to younger lawyers like yourself that don't have a lot of trial experience? How quickly should they pick up the phone and call someone like Alana, someone that tries a lot of cases, to be there by your side?
I think if they get in the 4-month range before trial and a case isn't going to resolve, they should bring someone in. And I don't know how I possibly could have done this trial by myself. There's so much going on at certain times, like especially preparing for closing and then doing jury instructions at the same time. All I could think the whole time was, how in the world would I have done this if I was by myself? Because, I prepared for closing while Alana worked out the jury instructions, which took forever. I can't even imagine. And then being able to split up some of the witnesses. And I wasn't as stressed out as I thought I would be. And I think that's wholly due to having co-counsel.
I'm assuming the answer is yes, based upon the result. But was it fun in the moment when you were in the trenches, battling trial, to be able to look over at someone like Alana and go to lunch and talk about the case?
Yeah. And there were a couple of low points too. We had a couple issues in the trial, and Alana just jumped right in and handled them. And I was probably a little bit dumbstruck, just like, oh, I wasn't expecting this. I don't know what to do. And she just jumped in and did that. And then being able to talk strategy on breaks and, before closing and what we're going to ask for, that was really helpful.
Fantastic. So before we kind of jump in, tell us a little bit about the facts of this case. And then I kind of want to go through the various aspects of trial, what your strategies were, et cetera. But give us a sort of a 30,000 foot view of what this case was about.
Okay. So our client was 22 years old. He was southbound on I-25 and traffic came to a stop, like it does a lot in that location. There was an older gentleman behind him in a red pickup truck who did not see that traffic was stopping. And he was looking away. He was distracted. When he looked back, he tried to swerve, but he still hit the rear of our client's car and scraped up the side of the car. And then he lost a tire and almost flipped and went down the highway a little bit more and hit a third car.
Oh my gosh. So you mentioned that your client was young. Tell us a little bit about your client's injuries.
So he had 3 herniations in his cervical spine, and then he had a herniation in his lumbar spine and one in his thoracic spine. He had driving anxiety, pretty bad driving anxiety. To begin with, it was really severe. He still is dealing with it and still has times where he has to pull over and, stop and practice some exercises to get calmed down. That was the main part. His neck was probably his main injury, and then the driving anxiety.
Were there any pre-existing neck, back issues that you had to deal with?
He was in a car crash in almost the same exact location about a year and a half before our crash.
Wow.
And he went to the ER for abdominal pain, but he ended up telling them he had upper back pain a little bit later, but they gave him some patches and medication and he was fine.
Did he have any follow-up care from that prior crash?
None.
Wow. Okay. So in this case, talk to us just a little bit about what kind of treatment he underwent.
So he started out with chiropractic care. And then when they got the MRI results, they recommended pain management. And so he went to pain management doctors, got 2 epidural steroid injections in his neck, which didn't help immediately, but eventually provided him with some pretty good relief. And that led to a 21-month gap in treatment. And he probably should have gone back sooner than he did. He was a kid and he just wanted to live his life. And he was sick of doctors. And so he finally, when he finished a semester of school, because he was a student, he got back in and did some more injections.
Now, before we sort of dig further into some of the nuances, I do think it'd be appropriate to tell our listeners the verdict, because they already have kind of like pretty good understanding of what this case is about, what they're dealing with. So please tell us what the verdict was in this case.
So the total verdict was $2,232,500.
Wow. So your client goes chiropractic and then pain management. Who was your pain management doctor?
His first pain management doctor was Dr. Wharton, but then he saw Dr. Gabriel at Mountain View Pain.
Were the 2 epidurals before this 21-month gap in care?
Yes.
Now, after the 21-month gap, what precipitated him? Because I think we've all had these clients, they're young clients, I'm going to be fine, I'm going to be okay. What precipitated him going in for more treatment, and what kind of treatment was it?
His neck pain had been gradually coming back and getting more and more severe. He wanted to get back in and get another injection, but they started him out with chiropractic care again and physical therapy. And they tried some trigger point injections. And then he did an epidural. And he got pretty good relief again from the epidural that he did. And then they started trying to treat the mid back and the low back too. And they did some injections in those as well.
Was there any type of surgical recommendation that was ever made on any part of his back or anywhere?
No, he did see the neurosurgeon and they recommended that he go back for some transforaminal epidural steroid injections, which we learned during the preservation deposition of Dr. Gabriel would have been diagnostic towards surgery.
Oh.
But he didn't have that done before trial. So the surgeon's report just wasn't clear that they wanted to do that to see if he was a surgical candidate. It wasn't written well.
So as time is going on, and I kind of, in my mind, I'm thinking you're probably getting close to the 3-year statute. Did you have to file because the statute was approaching?
We tried to submit a demand before the statute expired, a policy limits demand for the $100,000 policy. And we weren't able to reach any kind of a settlement, so we had to file. We filed right before the statute of limitations.
All right. Do you remember when you submitted your demand asking for policy limits, what your client's past medical were at that point?
I think they were about $30,000 at that point.
What was the story? Did you have sort of like this big workup of future medical care? Or is it just, look, he's got herniated discs all over his back. This is going to be a permanent condition. Pay up.
Yeah, it was more, he's young and this is going to be a permanent condition. And it's absolutely worth the $100,000 policy. And I think they started out at $22,000 or $28,000, somewhere around in there was the opening offer.
All right. And who was the insurer?
State Farm.
All right. So you make a policy limit demand. They offer less than the meds. Is that to the surprise of no one listening? And then you file suit. Is that kind of where we're at on this?
Yeah.
I think I said this at the beginning, but you filed in Adams County.
Right.
And who was your judge?
Arturo Hernandez.
So before we jump into the trial itself, were there any meaningful pre-trial settlement negotiations?
For the first time, the defense counsel in November asked us if we wanted to make some kind of a demand. And we did. And I can't remember if it was 500 or 550 that we demanded. And then they came back and rejected our demand and offered us $95,000 as a statutory offer of settlement.
All right. So I'm hearing you say no meaningful settlement negotiations, that you had made the policy limit demand, and then eventually State Farm comes and makes a statutory offer that's very close to those limits.
Right.
So kudos to you on a case. At this point, do you remember about were the meds still around 30, something like that?
They were about 66 because he had done the additional rounds of injections by then. So his meds had about doubled.
Okay. So you've got 66 in meds. Was it a difficult decision for your client to turn down the 95?
Not at all.
I
He
love
was
that.
pretty angry about the way he was treated. So he was not willing to even consider the 95,000.
So rear end crash, somebody's distracted by something, who knows what, probably a phone, but who knows. I'm assuming that once you got into litigation, that defendant accepted full responsibility for his actions. Would I be correct in that assumption?
No.
Tell us about that. So they denied liability?
Yeah, they denied liability, even though the defendant in his deposition admitted that he was distracted. He was watching a truck take the I-270 exit ramp, and that truck, he had been following that truck for about 10 miles. And he was watching the truck take the ramp when this happened. But in trial, he doubled down and said he didn't even think he hit our client at all. But in his deposition, he basically took responsibility in his deposition. So we were pretty surprised at trial when he said he didn't even think he hit our client. It was a shock.
Wow. Well, we are definitely going to talk about the cross of the defendant at trial. Before we do that, was there damage to your client's car?
Yeah, it collapsed the whole bumper in onto the driver's side rear tire and popped the tire. And then the truck scraped up the side of our client's car. It got totaled. It was pretty severe damage.
How does one total a vehicle and then deny ever making contact with that vehicle?
I mean, all he said in his deposition was that when he looked back, traffic was stopped and everything happened so fast that he didn't really know exactly what happened, which that I could understand. One of the witnesses estimated he was going 70 miles an hour. So,
Oh my gosh.
it was a fast, high speed crash. So I can understand that, saying, hey, it just happened so fast. I just jerked to try to avoid it.
And I don't know if this was said, I apologize, but he was in his 80s.
Yeah,
Yeah.
he was 78 at the time of the crash and 82 now.
I definitely want to ask if you addressed that in voir dire. But before we do that, how long after the crash did your client seek treatment?
It took him about 2 weeks to get in with somebody because that was height of COVID in October of 2020. And that was the soonest. I think he started trying to get an appointment within 2 or 3 days, but the soonest he could get in was 2 weeks.
Did you feel like that sort of initial delay in treatment was any kind of a concern or anything that affected the trial in any way? Or was it made perfect sense? He's a young kid. He's not going to run off to the doctor. Just something you didn't think about?
The defense tried to make a really big deal about it, but I don't think that it bothered the jury at all.
Okay.
Obviously.
We also covered that in voir dire.
Let's dig into voir dire. And Alana, am I correct that you handled voir dire?
Yes.
So going into voir dire, what were your main concerns?
Voir dire is my favorite part of every trial. I probably said that on the last time I was here. But what I like to do, because we had 20 minutes, which this one felt really fast. Normally I'm like, okay, I can do this. This one went really fast. But what I always like to do is just pick out the warts, the bad things, and hammer those. So obviously the gap was huge and the late start. So those were two big topics that I covered.
Any concerns? Sometimes when would it be okay to call the defendant elderly? We'll just say someone in their later stages of life. Sometimes I worry that they might have sympathy, but then I also think, well, some jurors are going to be upset because at some point you need to quit driving. Is that something you raised in voir dire in any way? Or was it a concern of yours?
I didn't raise it this time in voir dire. If I have time, sometimes I'll just bring up like, is anyone going to have a problem awarding a verdict against, an individual driver?
Mm-hmm.
But I did not talk about his age at that point. It was definitely a strategy issue throughout, like, how are we going to handle him on cross? And Jen and I talked about that a lot because he was visibly old and had several strokes. And it was like, is it going to be, oh, this poor guy? Or is it, like you said, he shouldn't be driving? And how do we handle that? We can talk about that when I did his cross. But in terms of voir dire, I didn't bring it up. If I had more time, maybe, but I didn't.
One question I've asked before, and I've never had the guts to do it in trial, but during his deposition, did anyone ask if any of his family members had ever expressed any concerns about his driving?
When he admitted having strokes
Wow.
prior to the crash and said that at one point he was, incapacitated and unable to drive for many months. I can't remember. I asked him, did you get tested or do anything, to help yourself make sure you were safe to drive again? And he said all he did was have some friends drive with him a little bit, and they said he was okay to drive again. So
in relation to the crash, when was the stroke?
I think it was about 4 or 5 years before the crash.
Wow.
Maybe a little less.
Wow.
He had
I feel like it was a
multiple
little
strokes.
less. I feel like it was like 3 years.
Yeah, it might have been two or 3 years. And he had multiple strokes, but one was really severe and left him, pretty incapacitated for quite a while.
Did the strokes come up in trial?
Yeah.
So, Alana, let's jump into the cross of the defendant, because I'm hearing all of this. How on earth is this guy denying liability on the stand? That probably explains your verdict, quite frankly. But like, how is this guy not accepting responsibility on the stand?
Yeah. And I mean, that was like the big theme of our closing and rebuttal close. Like, I tried to be very gentle with him, and I think I continued to be gentle. But, when I said to him, you admit you hit him. And he said, and by the way, we brought him in our case in chief. So
when did you, sorry to cut you off.
Yeah.
Was he your first witness, or when did you call him in your case in chief?
I think he was our second.
He was second. Yeah.
After
The police
the
officer testified first.
Yeah.
Okay. So he's early, like day one, afternoon of day one, defendant's on the stand. Tell us what that was like.
Yeah. So like I said before, I mean, he's clearly a very fragile older man that, I am empathetic towards and want to be respectful. But he got on the stand, and to be honest, I don't think was very likable. He didn't accept responsibility. He does still drive while he's walking around. I mean, and he drives a huge Ram. So if you see him in the parking lot, he's driving a big truck, right? And I don't think that's very good for juror perception outside of the courtroom. But so anyway, I tried to be gentle with him, but when he basically said I didn't hit him, I was like, I think I looked over at Melanie and I was like, oh, okay. This is fun. So, I was like, so you don't think you hit him? And he's like, no, I didn't hit him. I didn't hit him.
Oh my gosh.
And I said, and then I stopped, and then I just was like, you've had strokes, right? In your past, and Brendan didn't object somehow. And we got into how many strokes he had. And I said, are you still driving? And he said, yes. And I think we just it was maybe 20 minutes, 30 minutes, and just established, like, number one, this guy shouldn't have been driving at the time. He wasn't paying attention. I did get him to like acknowledge that he was distracted by the tractor trailer going off, and you're basically looking over here and you're just not looking in front of you, and laid down that kind of narrative. And that was all we needed to do. It was kind of a gift.
Did you finish the first day with him? Do you remember if that was your last witness that day?
I thought we started the morning with him, but I could be wrong.
No, we finished the first day with him.
Okay.
Yeah.
Gosh, what I love about that is you just picture the jurors going home that night with that testimony to think about. It's just unbelievable. And one of the themes that I've seen hosting this podcast, it's one of the reasons why I love doing this, is what I have seen in so many cases that go to trial is we're all afraid of bad breaks, and we all think about the worst things that happen. But so many times the breaks go in our favor. And then all of a sudden you have something like this. And without going to trial and giving yourself that opportunity, you just never know when something like this is going to occur, where you have someone that rear ends someone and then says, well, I don't even think that I hit him. That's just unbelievable. Of course, it's State Farm. So who did they hire to say that your client was not injured as badly as he claimed?
Dr. Stoll.
All right. Now, there has been much in our circle about Dr. Stoll. My first question to you is, objectively, how did he present at trial? What was his demeanor like?
I mean, he's really confident. I mean, he presents pretty well, but I think that I did a good enough job on cross-examining him that the jurors questioned all of his conclusions. I mean, his conclusions are pretty far out there for, trying to say that a 22-year-old had all of his problems were pre-existing degenerative disc disease. I think that's pretty far-fetched for a jury to accept that. So
that was the main gist. Did he give you that any of the treatment was reasonable? Maybe like the first follow-up, some chiropractic care, or what were his opinions?
In his report, he said 6 to 8 weeks of treatment was all that was reasonable. But in his preservation deposition, he said treatment through the second epidural steroid injection was reasonable. He was confused and he thought that was only about 5 months after the crash, but it was actually a year and 5 months after the crash. So, I pointed that out in cross-examination and he kind of was, he just had to eat it and accept it because that's what he said. But yeah, degenerative, it was all degenerative. He only needed a little bit of treatment. And then everything after that is related to the degeneration and not the crash.
So I have kind of a strategy question on how you handled that type of opinion, where this is all degenerative, but your client didn't have any symptoms before. So did you challenge the absurdity of disc herniations being degenerative in a 20-something-year-old, or did you harp on, well, look, he didn't have symptoms before, he's got symptoms now, so whether those herniations were there before or not doesn't really matter, he's symptomatic now. What was your strategy on how to deal with that in cross?
So I asked him about, did he have any records that said that my client had pain in his neck before this crash, which there's no history whatsoever of neck pain. And I made it clear that if those records existed, they would have been given to him. And, so how can he say that this was pre-existing if my client didn't have any treatment? And he said, I just believe that he had symptoms before this crash. So I basically called him out and said, so you're calling my client a liar.
Wow.
And the deposition,
Wow.
which Jen and I had talked about it because I had it in my outline and she was like, are you sure you want to go there? And I said, well, what else am I supposed to do? If he says that he believes my client had all these symptoms before the crash and that he's lying about it, then I have to ask him. So then a couple places after that, he kept saying, well, I'm not calling your client a liar. He brought it back up a couple of times after that.
In trial, he brought it up because you had brought it up in the deposition.
Well, that in his preservation, because I only did a preservation deposition of him. I didn't take a discovery deposition. So in his preservation deposition on cross, I asked him if he thought my client was lying. So,
by the way, can we all agree that we love when defense doctors are done by preservation? Not only because they're not there live, but it's like one less thing to think about at trial. You cut the clips, it's in the can. It's like, I just wish that they would do that every single time. It's so great.
I'd like to do it with all of them, to be honest. Or some
I
of
know,
them.
if only.
It's so much easier.
It's so much easier. Now, did Dr. Stoll make a big deal out of that prior crash with no treatment after?
Yeah. Yeah,
so he was trying to blame it all. He's essentially saying, look, there was this really bad crash before. He clearly still had symptoms, even though he wasn't reporting them. And that's the reason why I'm giving the opinion that I'm giving.
Yeah, that was his opinion.
And there was another crash in the gap, by the way.
Yeah.
Oh.
That's a pretty minor one. We actually had it on dash cam video and showed it to the jury. They tried to make it seem like it was bigger than what it was. It was a parking lot crash, so it wasn't even on the street. It was pretty minor.
Now, what did Dr. Stoll testify? I'm asking you about public information as to how much money he makes doing this kind of work. Were you able to sort of elicit a really big number for the jury?
Yeah, he said he makes about, I think it was like 1.2 million a year from just the exams. And he said in his preservation deposition that our affidavit only specified what he makes for the exams. So that doesn't include what he gets for consults and prep and depositions and trials. So if anyone's doing their affidavits for experts, make sure you include all medical legal work in your affidavit.
What is his percent of time done in private practice versus this?
I didn't really get that from him, but I think he doesn't do a lot of private practice anymore.
Oh, well, I guess why would you?
Right.
Why be inconvenienced with trying to help people when you can just, all right, I'll stop with that commentary. So obviously, you had an amazing result in impairment in this case. Did you have an impairment rating or permanency laid out by your experts going into trial?
No, we didn't.
So talk to us a little bit about that because it seems like there's lots of different ways to accomplish that goal. Some people really like to have impairment ratings, other people don't. Some people like it needs to be permanent, others don't. What, if you remember, was the actual testimony from your treating doctor as to how this condition would play out over time?
So Dr. Endress, who is the chiropractor, pointed out that there was ligament laxity seen on the initial x-rays of his neck, and he explained how that's a permanent condition, that it'll never repair itself. And then Dr. Gabriel said that the findings from the MRIs are permanent and they'll continue to affect him on a permanent basis. So we had both of those opinions. And then Alana actually came up with she tying some kind of something that's related to the client that makes it really easy for the jury to, use a daily per diem number. So we asked the client what he charges for a haircut because he's a barber.
Hmm.
And he charges $40 for a haircut. And so when we asked the jury to award permanent impairment, we asked him to give him $40 a day for the rest of his life.
Wow. Love that. Is that something that you tested with focus groups, or is that just brainstorming amongst yourself and like, this is what we're going to do? It feels right. And obviously it was right.
Just brainstorming. Yeah,
Wow.
during trial, trying to figure out the best way to ask for damages. So
Keith, too, I want to hop in on the
Yeah.
Cairo piece because
Yes.
this was, one of the trials that, with each trial, you have like some eye-opening situation, right? And in all of these years we've done this, a Cairo's a Cairo. And they're not our best witness. We need an MD, right? But I spent time with this Dr. Endress, who was phenomenal on the stand. I don't
yes.
think he's ever testified before. I can't recall. He was so knowledgeable to a point that it was what chiros do, I think, is more relatable in terms of the human body than some MDs. And so I spent some time with him and like this whole ligament laxity. And what I think we need to be doing, and what I took from this case, is we need to focus on how we're disclosing our chiros because they are our first line of defense. They are in the trenches when somebody's really in the start of their treatment, and they're there 3 days a week, right? So it's like, I focused on you're seeing him 3 times a week, which is way more than our pain management doc who sees him once every 5 months or something like that, right?
Right.
So you go an injection, he comes back. What was also really eye-opening, and defense opened the door on this, is, and then they tried to not let him testify to it, but he has biomechanics license and education, right? So he starts in his cross, starts talking about coup contra coup and concussions and, symptoms of concussion, and which we had a minor concussion in this case. And I'm just like, oh my gosh, I would never use a chiro necessarily to go into this, right? But they're treating docs, and all we have to do is disclose them with that information and those credentials, and they can be great, right? Like, as long as we kind of weed through, like, maybe even in voir dire, does anybody think chiro is, voodoo medicine, right? Like, he was an asset in this case.
Mhm.
And he
Absolutely.
gave us the permanent impairment with the laxity. Like, okay, your muscle's stretched. It's like a rubber band. That's done. You stretch a rubber band and you're done, right? Like, that's something somebody can understand.
Yeah, as you were talking about what Dr. Endres testified to about the ligament laxicity, this being a permanent condition, I immediately was thinking, is that something that you put in your A2 disclosure in the body, since he's a treating doctor, where you can stick a body in there, or were you able to sort of slide that in without objection?
We had to argue it based on the rule, right? Like ligament laxity is in his record,
Ooh,
but we basically had to argue that it's part of his occupation to understand what that means and what's the relevance of it and what's the prognosis of it. I don't think it specifically said in the disclosure, Melanie, correct me if I'm wrong, all the information that we really got out of him. But put it in there in the future so we don't have to argue because some judges don't like that rule of it's the comment to 26 of,
correct.
a treating provider is someone who can render opinions based on their occupation and whatever they do. And so instead of having to argue that right before trial and hope that the judge gets it right, just put it in the disclosure and talk to the expert when we're doing the disclosures, right? Like this is just another exercise of prepare your case early.
What I love about that, and I will throw in my 2 cents for whatever it's worth, because we are big proponents of that as well, in that when you have treating doctors, the fact that we get to go in and we call it, diarrhea of the fingertips in the expert disclosure, everything that you want to get out of this person. So like Alana was saying, if you meet with, and I've had great luck with physical therapists too, can testify amazing at trial. Same thing. You get a physical therapist to come in there. You've got these, I'm sure we all have boilerplate expert disclosures for treaters.
Yeah.
And then you just stick a paragraph in there of permanent, this is a permanent condition, da, 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 da. Oftentimes it's missed by the defense. And then if they do raise it, rather than get into this fight about what the comment says and whether or not, the doctor can testify about causation, if they never even said causation or the records aren't clear on it. I just love what you said so much, Alana, about setting, this would be like the practice pointer. Have a deadline in your system that's a month or two before expert disclosures, where you are asking yourself who's going to testify and what are they going to say, and then get it in your disclosures to avoid any types of issues. I mean, that is just wonderful, wonderful work on your part. Melanie, anything that you can add, being a paralegal, 20 years, expert disclosures, what can our listeners learn about how to avoid unnecessary fights and get the evidence they need at trial in?
Well, we didn't talk to Dr. Endres for expert disclosures. We just did the boilerplate disclosure. And once Alana and I met with them for prep, I was kicking myself because, he asked when we called him to set the prep meeting, he asked for all of the medical records after our client stopped treating with his facility. And I said, well, why do you really need them? And he just said, it just helps me. And he actually ended up getting to testify to some things that he wouldn't have been able, because I think on cross, he was asked, did you review the records? And he said, yeah, I actually did, And so I think my advice is just meet with all of them. If they had any significant part in your client's treatment, meet with them, ask them if they want to review any other records, list that in the disclosure, that they reviewed additional records, because like he ended up being a huge asset. I thought he was really well-spoken and did great with the jury.
And if you've been following, I'm sure anyone who's listening to this has been following the amazing verdicts that people are getting throughout the state. And so often it is the Dr. Endres or Josh Johnston or Evan Katz, these frontline treaters that are scientific and knowledgeable. I think they terrify the defense, because are they going to really go head to, toe to toe with any of these, well-based scientific providers? And the answer is no. It's just wonderful, wonderful work. So question, what did your case consist of? Who did you guys call? How many lay witnesses? And if you started, you said you took 20 minutes for voir dire. So you're doing, the first day is the defendant who didn't remember hitting your car. Do you remember what the second day and how quickly you were able to rest looked?
So we did Endres to start the second day, and then we played Dr. Gabriel's preservation deposition. And then we started direct of our client the second afternoon. And we called one of his friends out of order. We were considering bringing his father in, but we decided that we didn't need him. So we just brought in one of his good friends. And then we had to finish cross-examination of the client on Wednesday. And then we played Dr. Stoll's video preservation deposition, and then we played rebuttal. Because we did video preservation of Dr. Gabriel, they made us split the video into direct and rebuttal.
Which is also
Okay.
amazing. Like,
Yeah.
how nice is it
Right.
to call, like scheduling rebuttal experts is the worst.
Yeah. And I sort of one of the things that I try to do whenever we can, because I think sometimes we're so fatigued, we've done the trial and we don't think enough about rebuttal witnesses, and like having somebody come in at the end and really clean it up can be very, very powerful. Now, you mentioned calling Dr. Stoll, but was that the defense? I mean, had you
Yeah.
rested your case and then the defense called as their sort of only witness?
Yeah. He was their only witness.
Who defended this case?
It was Brendan Rodman and Kala Farina from Rodman and Rodman.
All right. So I'm hearing you say that your client was right near the end of your case where you're resting. Had you spent enough time with your client so that you believed your client was going to present really well, and so you felt comfortable sort of ending your case with him? I see some smiles.
I
What
think
was
we
the
need to
story?
talk
Was
about
it
what
strategy or?
happened.
Yeah.
Yeah.
He did really well in his deposition, like shocked me how well he did. And even in responding to a couple things that we hadn't prepped for perfectly. He was horrible on direct.
I
I
wouldn't
mean, there's
say he
just,
was horrible, but he was like very much I think the theme of this case became very evident of youth and that he's young.
yes.
Okay.
And his friend was young. Like they're just like kind of like cute and naive, and like they're not trying to pull the wool over anybody's eyes. Like
Right.
they're not tricky, they're not schemers, but it was a little too like we can't prep him. And we're laughing because here's a first if you're ever in this situation. He brought his outline to the stand when he came back from a break, the one that Melanie like a script basically. And he didn't look at it, but he was just like, hold it. Like he took it from like the prep room and brought it with him and like went through the rest of his testimony. And he gets off the stand and Brendan Rodman stands up and makes this big scene of he just brought something from the stand and he's been, also his phone like vibrated in his pocket twice. And he's like, he's getting fed how to testify and blah, 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 and made a big deal in front of the jury. Which delayed our case significantly,
Yeah.
by at least half a day. That we had to brief this issue, whether like the outline could be given to the jury and published, which is basically it's a question and answer, like we do with our, how we prep our clients. They shouldn't bring it to the stand. So basically, the rule has to do with refreshing recollection and what documents do you use to refresh your recollection. And so Brendan's arguing that any document that's used to refresh his recollection is admissible or can be used, right? And so we had to brief this whole issue, and there's nothing out there to really like no case law or anything. But basically, you need to prove that this document was used to refresh his recollection. And so Judge Hernandez pulls him back on the stand and asks him, like, not the question, did you use this to help you in testimony or refresh? He asks him, did you look at the document? Right? Did you look at the document?
Yeah. Right.
He said, well, I mean, like I looked at it, like I doodled on it, I was holding it, and that was it, right? And so that was like enough for Brendan to say he used it to refresh his recollection. I'm like, Judge, looking at the document is not like that's not the rule, right? You need to call him and ask him again. And Judge Hernandez was like, this is all off without the jury there.
Yeah. Yeah.
And he's like, I don't believe your client. I don't think his testimony is credible. So it doesn't matter if I call him back. And we're like, oh, good. The judge
Yeah,
doesn't
great.
actually believe our client. So that was just kind of like, oh shit, how's this going in front of a jury, basically? But that was a first.
So the practice pointer is you tell your client, don't bring anything to the stand. Nothing.
Nobody. Don't bring
It
anything.
was-
Don't bring your phone. Don't bring a pen. Nothing.
It was like his security blanket is what I'm thinking. That's 100% what it was.
Yeah. It
Yeah.
was something to touch, hands,
Yeah. Yeah. Wow. Okay. So we're getting to the point of closings. Melly, did you do first close?
Yes, I did first close.
Talk to us about what did that look like? Did you, were there specific jury instructions you focused on? Did you go through the verdict form and suggest numbers for the jury?
I did go through the verdict form and suggest numbers. I talked about a couple of the jury instructions because they got in, failure to mitigate. I forget. I think, division among, was this caused by the other crash? So I talked about the 2023 crash and how it was a minor crash. They saw the video. It wasn't that big of a deal. And then, went through all the numbers. And I didn't really talk about the economic damages a lot. But I asked them to award the cap on damages in non-economics without really an explanation, which I found out later totally confused them. They didn't know how we got the number. And then the $40 a day for the rest of his life. And I said in my closing, this is just a suggestion. You could give him less, you could give him more. That's what we're suggesting. And it told him what it was based on.
On this failure to mitigate, did Dr. Stahl say in his report that the failure to mitigate worsened your client's condition?
No.
Yeah, it's just interesting that there's some great posts about that recently. It just seems like it's so overused by the defense that I think I'm just going to really fight the heck out of that next time, if at all possible, because it seems like without that, they don't get the instruction. It's not like you can't speculate, but what do I know? I'm just a dumb lawyer. So the defense gets up, and did they admit liability in the closing? What did they do with this mess of a client in closing on liability? And also, did they suggest a number for the jury to award?
They said that his actions, the defendant's actions, were reasonable under the circumstances. And that was kind of their theme with, with the crash the whole time, that he acted reasonably, so he shouldn't be negligent. He wasn't negligent. And they didn't suggest any numbers. And I don't know that they suggested a complete defense verdict either.
They suggested the meds. They said, look at because we had the summary. And he say, look at the summary and basically calculate the 6 to 8 weeks or something like that.
So Alana, if you were doing rebuttal close, is that something that you had planned out in advance, or were you really just strictly listening and responding to what was occurring in the moment?
So it's funny that you asked that, because normally I listen and respond in the moment. And to this day, I think of all the trials that I did that, and I'm like, that was the dumbest rebuttal, right? Like, I know what they're going to say, so have it prepared in advance. And Melanie actually we had 30 minutes, and I think Melanie only used 20. So I had 10-minute rebuttal, which was huge, which was basically like another close, which was really nice. But I took the theme of, it's amazing that I have this notebook on my desk, is what I was looking at. They want to blame others. That's what their close was. And so I really did kind of take everything that I was planning on using and failing to take accountability, because they want to blame everybody else. They want to blame this other accident and, whatever, that he's 22, and they want to blame degeneration and all that. But the one thing they refuse to do is accept accountability, to the point that they don't even know if he hit him, right? Like, they're saying straight out that, which is completely against the evidence. So that's number one of how they don't accept responsibility. And then I also talk about, like, blame others. Should he be driving? He seems like a nice man. Should he be driving? Should he still be driving? I use that. And then I focused on his youth, like, to the point that I accidentally called him a kid, and I was like, sorry, you're not a kid. But we also had a panel that was ranged from maybe 35 to 50. So it was a relatively younger panel. Basically, I was like, this is reality. Think about a 22-year-old in reality. Like, he doesn't have problems. He doesn't have a PCP. He's having fun. He's cutting hair. He's going out with his friends. And he doesn't even go to a doctor. Yet they want to say that he's got all these problems. That is not reality. And that's basically was my theme of, like, they want to blame everybody. They want to blame these crashes. but this is reality. And those crashes happens to people all the time, doesn't change someone's life like this did. And it was nice. It was really nice to have all that time. Right.
Yeah.
But also getting back to your like co-counseling discussion that we started in the beginning.
Yeah.
This trial was also like really evident to me too. Like Jerry and I try a lot of cases together, so I've never focused on our personalities. But what was really cool in this one is Melanie and I have very different personalities in a really great way. Like Melanie's calm and collected and, stays calm the whole time. And I'm, like a little more fiery. I'm talking with my hands. I move around. I'm holding a notepad in my hand. And I think that was really kind of fun. And I think it's helpful because the jury gets to kind of decide who they like and who they want to listen to, when we are frequently being judged for our clients, right? Like if the jury doesn't like their attorneys, they're going to penalize our clients for it. So I thought that was really a fun way of like co-counseling is like Melanie is so calm and I'm very like, fight this. And she's like, I got it.
I think that Alana, I really think you're hitting on something that's super important because I heard Sari de Lamont was talking about a similar issue in that you should, because it was coming up for me in a case I have coming up soon. It's good to have a male and female lawyer because you don't know who the jurors are going to sort of connect with. And the same, that is equally true to people that have two different personalities. So I love that idea of allowing ourselves to be our authentic selves and then having the jurors sort of connect with one of us, hopefully.
Right. I mean, I just watched the Mendez, is it Mendez, the brothers,
Yes.
the documentary and how their second trial, like they hated their attorney, and she basically lost it for them because of how her presentation was. And it's like, that sucks, but that's reality, right?
Yeah.
Like,
Didn't that happen to Amber Heard in the Johnny Depp trial too? I think it
yeah.
was, but what do I know? So one of the things that happened in this case, which has never happened to me, and so I am so just straight up jealous, is the jurors gave you more than you asked for. Is that right?
Yes.
How on earth, please help me. How did you do that?
I have no idea. We had a great panel. And I think that they really took a lot of time to think through the jury instructions and how to award damages. And that's what I think.
Well, we talked a little bit before we went on air, and I think maybe you said something along the lines of, look, this is just a suggestion. This is just, something to come. I mean, you gave them license to give more, didn't you? And kind of the way that you handed the case to them.
Yeah, I did tell them, this is just my suggestion. You can give less, you can give more, but this is one way that you could calculate permanent impairment.
Something on that though, Keith, too. So
Yeah.
just for the future, and I think we're just going to keep seeing it happen. So there was a motion about, what was it, Melanie, about arguing or presenting our non-economic damages and how to do it. And they didn't want us to be able to, do a model or whatever, because it's not based on the evidence. And so I think we wanted to make sure, because the judge was like, you better make it clear that what you were suggesting is not evidence, but it's your argument. And so, that I think that's helpful too, because it's like, we're not telling you because there isn't specific evidence of this in the case, but here's what the evidence you can use to do it how you want, right? And we know that oftentimes they go low. They do what they want with that lower.
We mentioned before that this was State Farm, and I do think this is important for our listeners, and that you had made a policy limit demand. Did State Farm issue a comfort letter?
Yes, the week before trial.
Okay. Now, what about any post-trial motions? Where are you guys at on getting paid?
So we had to file a motion to exceed the non-economic damages cap, which was denied. So we lost about $235,000, I think, right around in there. So the verdict got reduced to like $1,991,000, I think is what it ended up. And then there's a motion that was filed they're asking for a new trial on damages, the defenses.
On what basis?
that they talked to a juror who told them the jurors were confused about the life expectancy instruction. And so they just made up their own way to calculate what was owed to our client.
So do you know, did the defense hire a private investigator to go out and speak to the jurors after the trial?
It doesn't sound like it. And they didn't include an affidavit or anything. So I don't think that the information they got was really strong, or they would have gotten an affidavit.
I mean, do you guys have any idea what happened? Did some juror call the defense lawyer or no idea?
No idea. They didn't stay to talk to the jury after trial. So
They must have
Wow.
called them.
yeah.
The other piece of the motion for new trial too, which I'll be curious to see how this works, is they said the economic damages were not based in the evidence. And so in speaking, so our past meds were $66,000 and our economic damage award was what, like 200?
232.
Right. And so there was some suggestion that so there was no lost wages claim either in the complaint or proceeding to trial, but he testified that he missed work. He couldn't work full time. His friend was like, all of our friends' hair looked like, bad because our client's not cutting their hair. They didn't have a barber to go to. So there was like testimony that he wasn't working. And Melanie asked him, how much were you making? How much would a haircut cost? And it was $40. And so they kind of took that. So we're not really clear where that extra economics come from. Does it come from the wages, or does it come from futures, which we didn't have a Acumed or a projection of future costs? They were able to kind of look at what an injection costs in his past meds and potentially take them out, right, to life expectancy. But where part of the motion, and it's a little unclear, is in discussing with the jury, they said, well, we used the $40 a haircut as part of the damages. And whether that's to the permanent impairment piece, like that's how they used the calculation and they took that beyond the life expectancy reading, or did they actually give him lost wages that there's no line item for it, right? So I think that that's all kind of part of this motion.
Well, so two quick follow-up questions on that. Number one, did they object to the testimony about the lost wages during trial?
No.
Well, good luck on that. And then the second one would be, was there any testimony from Dr. Endress or anyone about any, future chiropractic care or anything that they're going to need in the future? I mean, anything.
Injections, right?
Yeah.
Really?
Because he's still actively treating.
Oh.
So when I did Dr. Gabriel's preservation deposition, I asked him, going forward, what treatment do you anticipate him needing for his neck and then for his upper back and his low back? So that was all part of the testimony, that he still needed treatment.
Wow.
And he did tell us how much an injection cost at their clinic as well.
Well, and the beautiful thing, as I told you off air, is that, that's great. Let that motion sit at the trial court as you're earning 9% interest on this verdict that just will continue to accrue. So Alana, Melanie, holy smokes. I hope that you are still living in the glow of this righteous verdict, because it is a true, true home run. I just am so amazed and proud of you guys. Thank you, Melanie. Thank you, Alana, for coming on again. And I can't wait. Now, Alana, come back again. Melanie, come back again. We'll keep having you come back. Just keep hitting those home runs. And then eventually the people that listen are going to hit some home runs too.
Yep.
Thanks, Keith. Appreciate
Thanks
it.
a lot for being on, guys. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's Courtroom Warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.